Hey everyone, Rob Ryder. Today, no commission, no authority. And today would be Wednesday, June 15th, 2016. And we're going to find by just studying a little bit on the Constitution of the United States, certain things have to happen that apparently aren't happening. And so the people who think that they're actually officers of the United States, like a district court judge, federal judge of any kind, well, they better be able to prove it. Because it says in Article 2, Section 3, and this is talking about the powers of the President, he shall from time to time give to the Congress information of the state of the Union and recommend to their consideration such measures as he shall judge necessary and expedient. He may, on extraordinary occasions, convene both houses, or either of them, and in case of disagreement between them with respect to the time of adjournment, he may adjourn them to such time as he shall think proper. He shall receive ambassadors and other public ministers, and he shall take care that the laws be faithfully executed, and shall commission all officers of the United States. Now, somebody else could appoint them, but he, the President, shall commission all officers of the United States. As it turns out, it would be a document that is sometimes in the old days would have been called a letters, L-E-T-T-E-R-S, a letters patent, P-A-T-E-N-T. And if they don't have one of those signed by the President in a little procedure that we're going to go through that they have to do, then they're not who they say they are. And not only do they have to have it, they have to have signed it. Which means then it would have had to go on to somebody else to be put into a record that they had done so. And so, there should be a paper trail for all this. And we could say, well, why bother with all this? I mean, they're going to break the law anyways. That could be, but I don't know that everybody that needs to know it knows it. What I want to do is make sure that people like this know it. That'd be General Dunford, 4-star General, United States Marine Corps, Chief of the Joint Chiefs of Staff. So, let's let him know it. Sir, I don't believe any of these officers in the United States are properly appointed. I don't believe that they have a commission from the President of the United States, and I'll show you some evidence. And now the reason I can say that is because, when I put a video up, within just a matter of a couple minutes, there's numerous views on it. It's like, well, I know people aren't just waiting for my stuff to show up to watch it. It must be kind of already being watched or being looked for or whatever, so yeah, I hope one of them's the military. I've sent enough complaints to them about this stuff. I hope they're watching me. Absolutely. I'm not the problem. I'm trying to be a solution. And I am Rob Ryder. My email address is courtofrecord@aol.com. And my phone is 616-712-6179. It's Michigan, right? So don't call me at crazy-ass hours, and I just hope that not too many people call. There's only so many hours in the day. So let's get into this a little deeper. So what happens also in Article 2 of the same Constitution, Section 2, hey, that'd be the one just before the one we looked at. We could find that, without reading the whole thing, and he shall nominate, and by and with advice and consent of the Senate, shall appoint ambassadors, other public ministers, and counsels, judges of the Supreme Court. Didn't say anything about justices, judges of the Supreme Court, and all other officers of the United States whose appointments are not herein otherwise provided for. Again, they can be appointed many different ways, but it doesn't change the fact that they still have to be commissioned by the President. He gets the last say about who's working for him. Right? He can't be an expert on everybody, so they have it. Congress has made it so courts of law, heads of departments, the President without consent, there's various ways people can be appointed to an office. That's all good. But they can't get by this. Shall commission all officers of the United States. So ask for the commission. And that's what I'm doing now, and I haven't seen one yet. And we'll get into that more in a bit. The President shall have power to fill up all vacancies that may happen during the recess of the Senate, by granting commissions which shall expire at the end of the session. Now, we just read up here that the President can adjourn one house or both houses or whatever he wants, respect the time of adjournment. He may have adjourned the Senate. The Senate may actually hardly ever be in session. Maybe they're only in session when they're in executive session. That's the only time that they're actually in their office. But that's only if they've done the things they need to do to be holding office. Also, which was covered in other videos, and really don't have time to get into that. But I do have time to ask you this. Can you please donate? Please, 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 please. Man, we're getting so close. I got to keep asking for money. You know, that's what God wants me to do because it keeps me humble. And He knows I'm not really, really humble sometimes. What can I say? I'm a sinner. But He's accepted me back, and I'm just doing His will every day. I do His will. This is His will, that I do this, and I point out to these people what's being done wrong. So please, the PayPal account is ashleyrytlewski@gmail.com. ASHLEYRYTLEWSKI@gmail.com. That's not my email address. That's the PayPal account. My email address is courtofrecord@aol.com. If you want to contact me, that's the one to use. If you want to send me $1 or $2, please send it to this PayPal account or mail it to me. Robert Rytlewski. Okay, that's closer to that's not my full legal name, but it's my first name and last name. Actually, it's part of my first name. I don't have a middle name. My first name is Robert Allen. It's my given name. I was given one name, has two different parts. They sound the same to me as my mom called me. I knew who she was talking about. Anyways, but for mail purposes, Robert Rytlewski, 10955 14 Mile Road, Northeast, Rockford, Michigan, 49341. Okay, we'll get into this in just a second, but this is Article 3. Well, we should get into it right now. Section 2. The judicial power shall extend in all cases in law and equity arising under this Constitution, the laws of the United States, treaties made and which shall be made under their authority, to all cases affecting ambassadors and other public ministers and councils. So that would mean there would actually have to be one for them to have jurisdiction. For all cases of admiralty and maritime jurisdiction, controversies which the United States shall be a party, controversies between two or more states, between state citizen and citizens of another state, blah, 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 blah. We're going to find out that this is the ones that are, well, of interest for this, because we could go all the way back to this idea about the commission to Marbury versus Madison, 1803. This is right out of Wikipedia, where it says, was a landmark United States Supreme Court case in which the court formed the basis for the exercise of judicial review in the United States under Article 3 of the Constitution. Okay, that could be, but was that all that happened? Let's read on. The landmark decision helped define the boundary between the constitutionally separate executive and judicial branches of the American form of government. The case resulted from a petition. Okay, so the case resulted from a petition to the Supreme Court by William Marbury, who had been appointed Justice of the Peace in the District of Columbia by President John Adams, but whose commission was not subsequently delivered. Apparently, Marbury knew, hey, I can't be a Justice of the Peace unless I have a commission. And they're saying that it was held up by, but whose commission was subsequently delivered. Let's go on. Marbury petitioned the Supreme Court to force the new Secretary of State, James Madison, to deliver the document. So first of all, was James Madison actually properly commissioned at the time this happened? If not, well, then the court wouldn't have jurisdiction as far as him being an ambassador of the state. But more importantly, as we'll see, the court, with John Marshall as Chief Justice, found, firstly, that Madison's refusal to deliver the commission was both illegal and correctable. Well, if it was illegal, then that would put it shall extend to all cases in law and equity, even if he wasn't a public minister because he didn't have a commission. Because you don't have a commission until the president gives it to you. And, then there has to be evidence. The documentary evidence has to be filed for record. Remember that, sir? I know you do. Okay. Let's go on then. So what did they say? Nothing less. So the chief judge said that what Madison did was a crime, and it was correctable. Well, how would that be? Well, point it out as a crime and have it prosecuted. Nothing less, the court stopped short of ordering Madison, not by order because of a court case, but by a writ of mandamus, which isn't a court case. That writ of mandamus is an administrative process, and it's done by whoever has superintending control. So nothing less, the courts stopped short of ordering Madison by writ of mandamus to hand over Marbury's commission, instead holding that the provisions of the Judiciary Act of 1789 that enabled Marbury to bring his claim for a mandamus to the Supreme Court was itself unconstitutional, since it purported to extend the court's original jurisdiction beyond that which Article 3 had established. Article 3 didn't establish you could bring a writ of mandamus to the Supreme Court. It established that you could bring cases in law and equity, right, to the Supreme or the inferior court. So at the end of the day, this should all, because Marbury took his to the Supreme Court, then this would apply to them. They would have original jurisdiction in this, because they have the judicial power. The judicial power of the United States shall be vested in one Supreme Court, so they have it, and in such inferior courts as Congress may from time to time ordain, when they have it. But they're hiding those from us, but the Supreme Court is still sitting where it is. Yep. So, my point is, from reading this, what we should understand is, well, somebody didn't have a commission, therefore they didn't hold an office. This guy who didn't have the commission, he went, Marbury, and submitted for a writ of mandamus, which was a provision in the Judiciary Act of 1789. So that's what he based it on. But the Supreme Court came back and said that that section of the Judiciary Act was unconstitutional because it extended the court's original jurisdiction beyond that which Article 3 had established. Okay, so where was the guy left? Well, he was left with the fact that he was told what Madison did was a crime, and he still doesn't have his commission. So he should have prosecuted it as a crime and gotten the commission, but that may not have been the intention the whole time. The whole intention may have been to set this precedence to use from then on. And so if you don't have a commission, you don't hold an office. And that's what we need to check on. And there's a lot more in this, but I don't have time to go through it all. Right? There's just so much information you come across, and it's hard to pare it all down, but I don't know that all of it's necessary for our purposes. But what might be necessary for our purposes is cancel. I got to close this out. See you, General. Just make sure you guys are watching. That's all I care about. Okay. So pretty much anything I show you, you can find online yourself. There isn't, none of the stuff is a secret. It's just you have to take the time to go find it, and that's what takes the time. And that's what I do. All right, that's why if you can help a brother out, there's the place to do it. Just stop right now for a second and write these down. Go back and start watching the video. I'll be in the same place. See, here I am, still here. Okay. There is an office, or I guess we'll call it an office, Congressional Research Service. Hey, it works for the Congress. And they put out all sorts of pamphlets and so forth. So this guy named Dennis Stephen Rutgers, if you were just to Google his name, you'll see he's written all sorts of things for this Congressional Research Service. Some of them about the appointment process for U.S. Circuit and District Court nominations. And that's what this is. I want to know, hey, is that District Court judge, is he actually appointed properly? Can he prove it? By what authority does he claim to be a judge? I want to see the frickin' proof. Well, he was involved in another one, the Supreme Court appointment process. Well, there you are. Between these two, let's see if we can figure out what it takes for these people to actually be appointed. Okay, so if I go to page 49, because, you could read this whole thing, but I don't know that you need to. Most of it's about what's supposed to happen in the Senate to get to the point of being confirmed, right? But I'm interested in, what happens after they're confirmed. And so here's what it says about after Senate confirmation. Under the Constitution, the Senate alone votes on whether to confirm presidential nominations, the House of Representatives having no formal involvement in the confirmation process. If the Senate votes to confirm the nomination, the Secretary of the Senate then attests to the resolution of confirmation and transmits it to the White House. In turn, the President signs a document called a commission, officially appointing the individual to the court. Then the following technical steps occur. Oh, this would be the procedure, right? You don't follow the procedure, you don't get your frickin' commission. It's just that simple. I spent 10 years in the Army, and I was an NCO, and I can tell you what a no-go test is. Either you frickin' pass or you don't. If you can't follow these procedures, you're not going to pass. The signed commission is returned to the Justice Department for engraving the date of the appointment. If you can't check that off, it didn't happen. And for the signature of the Attorney General. Oh, now we got to have a date of appointment and a signature from the Attorney General and placing of the Justice Department seal. 3 things had to happen after it was signed by the President. The signed commission goes to the Justice Department. They put the date on it. The Attorney General signs it, and they put the Justice Department seal. Now, it doesn't say the Department of Justice. It says Justice Department. I think that's interesting. What is the Justice Department seal? Nevertheless, then the Deputy Attorney General then sends the commission by registered mail to the appointee. Oh, now we got a paper trail. I want to see the registered mail receipt that shows that you sent the commission to the appointee, along with the oath of office and a photocopy of the confirmation document from the Senate. So there's numerous pieces of paper that are being sent from an office, and they do have an office called Deputy Attorney General. I just hope that that's what I wrote, is the Deputy, right? When you write the Deputy Attorney General, that's in either uppercase or proper case, and this here is lowercase. And anything in lowercase just means it's somebody's duties. It's not necessarily the title of their office. Where if it's in all caps, well, that's the title of an office. If it's in proper case, it's the title of an office. I guess if it's in all caps, it's the title of a corporation. But anyways, it's not somebody's duties, and these are people's duties. Who has the duty of the Deputy Attorney General would send the commission by registered mail to the appointee along with oath of office and a photocopy of the confirmation documents from the Senate. Upon the appointee's receipt of the commission and accompanying documents, only the formality of being sworn into office remains. So until this point, they're still not in office. They have the papers, but they ain't there yet. In fact, however, the incoming justice takes 2 oaths of office. Well, imagine that. A judicial oath, as required by the Judiciary Act of 1789, and a constitutional oath, which, as required by Article 6 of the U.S. Constitution, is administered to members of Congress and all executive and judicial officers. That would be 5 U.S.C. 3331. In recent years, the usual practice of new appointees has been to take their judicial oath. That's the one under 28 U.S.C. 453, I think it is. Well, we'll get to it in a second. They take that one behind closed doors, and as desired by the presidents who nominated them, to take their constitutional oaths in nationally televised ceremonies at the White House. So they're not on the same piece of paper, right? They're 2 different oaths. Okay, so A, B, C, D, right? Just check. If they didn't do all these things, hey, it didn't happen. What I want to see is the piece of paper, when it's done, that they've done all this. Because most, I've shown before, this called the appointment affidavits, standard form 61, SF-61. Find it online. Upon this, that document goes into people's official personnel folders at the Office of Personnel Management, and it shows it's evidence of their appointment. That's what it's supposed to be, but the way it's written, it bifurcates the wording of the required oath of office and actually splits it in half, and so it inserts words into something that wasn't there before, and so then therefore it's a no-go. It's not the oath that's been mandated. All right, so this was in Supreme Court appointment process, roles of the President, Judiciary Committee, and Senate. Right, Order Code RL 31989. You Google some of this, and you're going to find it. Isn't that hard to find? Just put in Supreme Court appointment process into Google, and it'll take you to it. This is the other one, the appointment process for U.S. Circuit and District Court nominations. It'd be an overview. And again, all the good stuff is at the end. This is on the 44th page of a 48-page PDF where it says after confirmation of nomination. But this part I want, post-Senate appointment steps. 140. Upon notification of a nominee's confirmation, the President performs the next step in the appointment process, the signing of the nominee's commission. Hey, there's a piece of paper signed by the President that has nominee's name on it. I wonder if that name is using a middle initial. Or is it the full legal name? What would you think on an official document? The commission is a formal document empowering the nominee to assume the judicial office. There you are, man. That's as lawful as you can get. Which the President must sign before the nominee may begin his or her new duties. Well, yeah, he has to. But there's a few other points that we'll see need to be done too, but that's certainly one of them. Until the President signs a commission, you can't be a appointed officer. The date of the nominee's commission is the date of the President signs it, which usually occurs within a few days of the Senate confirmation, but can also occur on the same date as the confirmation itself. Right? So normally this all happened at the same time. Because, okay, let's think about it. Because it said they had to take these oaths of office, and they do the one in a televised event at the White House. Well, then that could be when they're just doing all this on the same day. All this stuff would be happening at the same time, or should be. But it doesn't have to. The commission is transmitted to the Department of Justice, which then sends it as well as a packet of other documents to the nominee. Yeah, I think we read that before. The appointment commission packet sent by the Department of Justice includes various forms to accompany the statutory oath of office, which each circuit district judge must take before exercising the judicial authority of the state. So it is more than just the President signing. Before they can exercise the judicial authority, they have to have signed their oaths and the commission. The oath of office is orally administered by someone legally authorized by state and federal law to administer oaths, including the chief judge or another judge of the court to which the nominee is assuming his or her position. Additionally, in some cases, the home state senator of a nominee has administered the oath of office. The oath is a combination of the judicial oath of office required of every justice and judge of the United States under 28 U.S.C. 453 and the general oath of office to all federal government officials set forth in 5 U.S.C. 3331. And I gave us this little footnote we're going to look at in a second. So I guess what they, on the other PDF, that was for justices of the Supreme Court, was said part of it's done with the President. This here is a little bit different situation, it looks like, where, everything is sent to the guy's court, and that's where he does it. So you would think that human resources of whatever court the judge is at would have copies of all this paperwork. Well, I've asked my local one, and I'm still waiting for an answer. At the time the oath of office is executed, the nominee himself or herself must also sign and date the commission. Must also sign and date the commission. Must also sign and date the commission. Hey, they got to sign and date their commission. If two or more confirmed nominees to the same court sign their commissions on the same date, well, first of all, they got to sign it. Seniority is determined by seniority of age of the nominee. This process, receipt of the package from the Department of Justice, administering the oath of office to the nominee, including obtaining his or her signature on the commission, typically occurs within a week or two of Senate confirmation. In some cases, however, a nominee might wait longer for professional reasons to take the oath and sign his or her commission. There you are. So until they do, they're just an attorney who's licensed to practice law in that particular court. Or they couldn't have, because to be a judge, you got to be an attorney licensed to practice law. So there you go. So at that point, they could have been. But until they sign their oath and their commission, they are not an officer of the United States. For example, a law professor who is confirmed as a United States District Court judge might wait to sign her commission until after she has finished teaching for the semester. Well, how many times a law professor become a U.S. District Court judge? Does that happen very often? I thought they would have been a judge someplace else. I guess I don't know how they become judges. All I know is what it takes for them to be a judge. And I want to see the damn signed commission, signed by the president, signed by the attorney general, date engraved by the Department of Justice with the Department or the Justice Department seal, then forwarded by the Deputy Attorney General to the appointee, who has to do A, B, and C. Sign the commission, sign his oaths of office, and so on and so forth. Typically, the last step in the appointment process is the investiture. That would be getting your instruments of office. At this ceremonial event, attended by family and friends, a new judge is sworn in yet again in the courtroom. The ceremony, however, is not required for the nominee to assume office and can take place weeks or months after the oath of office is executed. Still have to execute the oath of office, but it can, months later, you can go through the little dog and pony show. Now that footnote 155, which talked about, where was that exactly? Right here, where it talks about the oath is a combination of the judicial oath of office required of every justice and judge of the United States under 28 U.S.C. 453 and the general oath administered to all federal government officials set forth in 5 U.S.C. 3331. And here's the footnote where it says the exact wording of the statutory oath of office taken by U.S. Circuit and District Court judges is as follows. And then it's written out. That's just a little bit too hard for me to read, so I'm going to go this way. Where, okay, this is the part that's in that the guy says this is what they're taking. This is the exact wording, according to the gentleman that wrote this book. And we won't need this anymore, so we can go back to the beginning, right? The Congressional Research Service, Dennis Stephen Rutgers, I emailed him also, asking him these same questions, says that this is the words they take. Right? So the question is, does this oath satisfy 28 U.S.C. 453, oaths of judges, justices, and judges, and 5 U.S.C. 3331, which is the oath of office for everybody but the president, who's an officer of the United States. Elected or appointed to an office, I think is how they put it. So, I insert the federal judge's name. Okay, that's the same. Do solemnly swear or affirm. Yep, that's the same. That I will administer justice without respect to persons. That I will administer justice without respect to persons. So we're good to the first comma. And do equal right to the poor and to the rich. And do equal right to the poor and to the rich, comma, yep. And that I will faithfully and impartially discharge and perform the duties incumbent upon me as, and I will faithfully and impartially discharge and perform the duties incumbent upon me as, got a place to insert the office, under the Constitution of the laws of the United States. Under the Constitution and the laws of the United States. under the Constitution and the laws of the United States. Oh, then we got our first semicolon. And, well, hey, that isn't what it says to do. It wasn't a semicolon, it's a period. So help me God. That's not in here. Right? So they did not take the exact wording exactly as 28 U.S. Code 453 says, and as a Staff Sergeant of the United States Army, I have to say, well, son, that's a no-go. Get back in line and do it again. Okay, but let's continue on. And that I will support and defend the Constitution of the United States. Well, that's starting here. That I will support and defend the Constitution of the United States. So I, A, B, do solemnly swear, right, is not in the oath for 5 U.S.C. 3331. It didn't tell them to combine them. It said to take 2 oaths. And right, so this is this same bullshit is what they did on the Standard Form 61 for people that would just be taking the 5 U.S.C. 3331. Right, because this other one's just for judicial justices and judges. But it isn't necessarily for special agent of the Inspector General. Or the Inspector General himself, as far as that goes. They be taking 5 U.S.C. 3331. And so they did the same thing in the standard form where I, A, B, do solemnly swear that I will, or that is outside of the area called the oath of office, where it says oath of office, then it says I will support and defend the Constitution of the United States. It goes on from there. So this is, this would be called the rule of law. And the rule was follow the law, and the law wasn't followed, so they didn't follow the rule. They need to do it over. And until they do, they're not holding the office. They're just pretending to hold the office. All right. Ain't that sweet? So where are we going next? So, right, I didn't say it. These people did. And all I can do now is show you a few things that I've done since, and I'm waiting for answers. But, if you have a court case in a federal court, you might be demanding to see, just stand up and tell them, I demand to see your appointment. I want to see your letters patent. And in fact, where is that? I need to read that. Okay. Where's the United States Attorney? We're going to talk about that in just a minute. District courts. Oh, okay. Hang on just a second. Okay. Again, from Wikipedia. Commission. As a document. Not like a commission like the Federal Election Commission or all these other commissions they talk about. No, we're talking about the document. A commission is a formal document issued to appoint a named person to a high office as a commissioned officer in a territory's armed forces. Commissions are typically issued in the name of, if not signed by, the head of state. In the Commonwealth realms, other than the United Kingdom, they may be signed by the Governor General and representative of the monarch, who is also Commander-in-Chief in and over that realm. That's what a commission is, and they talk about doing a commission. Right? Now, this is the United States of America we're talking about, not the United States of America. Look at your money, right? Front and back, it says the United States of America. Now, if you have a passport, go look at it, or look at a passport online for the United States. It says United States of America. 2 different jurisdictions. The United States of America is the proper style of the republic formed under the Article 1 of the Articles of Confederation and Perpetual Union. United States of America is a kingdom that Prince George III claimed for him and his successors in the Treaty of Paris, 1783, very first paragraph. Nevertheless, a commission is a formal document issued to appoint a named person to a high office, or as a commissioned officer in a territory's armed forces. Named person. The name on the commission is the person that has the power. No commission, no power. Commission with whatever name, well, that better be the name they use on their documents, or it has no power. Terminology. Because the wording commission can also refer generally to an individual's duty, the more specific term commissioning parchment or commissioning scroll are often used to specify the commissioning document. However, the document is not usually in the form of a scroll and is more often printed on paper instead of parchment. In Canada, there is a differentiation of terminology according to rank. Officers are accorded commissioning scripts, whereas chief warrant officers are accorded scrolls. Excuse me. So, now you'd have to go see what the definition of a script and a scroll is. But I'm not in Canada, so I'm going to move on. United States. Article 2, Section 2 of the United States provides the President shall commission all officers of the United States. Actually, it's Section 3. But, okay, hey, I'll go with it. Article 2, Section 2 of the Constitution provides the President shall commission all officers of the United States, including officers of the uniformed services as well as civilian officers. I guess it does, because 3 says that they have to, so whatever it says in 2 is just assuming that you understand the President needs to commission you people. Commissions of officers in the armed services are issued in the name of the President, although authority to sign on the President's behalf is generally exercised by the Secretary of the Department in which office is being commissioned. This includes not only commissioned officers, but also commissioned warrant officers. Warrant officer in the pay grade W2, W5. Warrant officers at the grade of W1 are appointed by warrant by a secretary of the respective services, except in the Coast Guard, where they are appointed by a secretarial commission. The commission of a newly commissioned officer reads, right, so now if somebody in the military, some commissioned officer was to have their paperwork available, we could see that it says, the President of the United States, to who shall see these presents greeting, know ye that, reposing special trust and confidence and patriotism, valor, fidelity, and abilities of General Dunford, I do appoint him Joint Chief Staff in the name of the rank, okay, and it goes on and on. The officer will therefore carefully and diligently discharge the duties of the office which he appointed by doing and performing of all manner of things thereunto belonging. Okay, so this is for a commissioned uniformed officer. Examples of commissions of civil officers. Oh, this would be like United States attorneys and federal judges, or they're commissioned, or they are commissioned military officers, in which case they're guilty of treason if they don't have their commission. The constitutional requirement mentioned above that the President commission all officers of the United States includes a wide range of civilian officials, including justices of the Supreme Court and other federal judges, U.S. attorneys and marshals, the heads of executive departments, sub-cabinet officials, down to the level of assistant secretary, diplomatic representatives, and members of the Foreign Service are among others. Commissions are issued in the name of the President, either under his own signature or that of an official expressly delegated to act on his behalf, and under either the Great Seal of the United States or, if prescribed by law, the seal of the department which the appointment is made. So, is the Judicial Department seal, the same as the seal of the, the Justice Department seal, the same as the Department of Justice seal, and is either of those the Great Seal? Whatever it is, needs to have a seal on it. A typical commission for a presidentially appointed Senate-confirmed civilian official in the executive branch would read, John E. Doe, President of the United States of America. So he will use his middle initial. This will be the President. To all these present shall come greeting. Know ye that, reposing special trust, confidence in the integrity, ability of Rebecca Francis Rowe, so they use the person's full legal name. Don't look to me like they're using any middle initial. I have nominated, and by and with advice of consent of the Senate, do appoint her Secretary of Transportation to authorize and empower her to execute and fulfill duties of the office according to law, and to have and to hold the said office with all powers and privileges thereunto of right appertaining unto her, the said Rebecca Francis Rowe, not Rebecca F. Rowe, during the pleasure of the President of the United States for the time being. And testimony whereof I have caused these letters to be made patent. Hey, that would be a letters patent. And the seal of the United States to be hereunto fixed. Done at the city of Washington this 2nd day of December in our year of our Lord, 2005, and on the independence of the United States of America. Right, now this is United States of America. This is King George's jurisdiction. The 213th. By the President, Great Seal, Secretary of State signature, on and on and on. So, where's the paper that has all this? Well, hey, did you get a chance? Now's the time. Okay, what next? Hang on, I gotta reload. Okay, what we're gonna be talking about next comes out of the U.S. Attorney's Manual. Right, so if you Googled U.S. Attorney's Manual, you would eventually find this spot on the Department of Justice website, and it's actually in Title 3, which is Executive Office, United States Attorneys. And actually, what we're going to be looking at is 3.2. United States Attorneys, AUSAs, which is Assistant United States Attorneys, Special Assistants, and the AGAC, which is whatever that is. It's an agency of some kind that, well, I should go find out what it is right now. History of the Attorney General's Advisory Committee of the United States Attorneys. That's who AGAC is. I haven't checked out who they are. I just happened to notice it was on here. It's of interest. And we're going to look at that section here in just a second, as soon as I remember where I put it. Okay, it's right here. All right, United States Attorneys. The United States Attorneys serves as the chief law enforcement officer in each judicial district and responsible for coordinating multiple agency investigations within the district. There are currently 93 United States attorneys stationed throughout the United States. You can see here they say United States Attorney. It doesn't say U.S. It says United States Attorney. And right, and it's all proper case. So it's like, well, that's that's somebody's the title of somebody's office. It would seem. The Office of the United States Attorney was created in the Judiciary Act of 1789, which provided for the appointment in each district of a meet person. I need to go see what meet means. Learned in the law to act as attorney for the United States, whose duty it shall be to prosecute in each district all delinquents of crimes and offenses recognizable under the authority of the United States, and all civil actions in which the United States shall be concerned. Initially, United States Attorney were not supervised by the Attorney General, blah, blah, blah. You can read it all yourself. But something happened in this Act of August 2nd, 1861, charged the Attorney General with the general superintendence and direction duties. That's where you use a writ of mandamus, is with whoever has general superintending control. Because you're asking them to issue an order. A writ of mandamus isn't issued through the court. It's issued as an executive order to a subordinate telling them to go do what they're supposed to do. Or a writ of quo warranto is to say, well, by what authority are you doing what this man says you're doing? While the precise nature of the superintendent's and direction was not defined, the Department of Justice Act of June 22nd, 1870, got to read that. Act of June 30, 1906, I got to read that. Clearly established the power, because whatever it said, it established the power of the Attorney General to supervise criminal and civil proceedings in any district. And so the Attorney General has superintending control over the United States Attorney. So if the United States Attorney isn't doing what they're supposed to do, then we're supposed to take it to the Attorney General. And the United States Attorney is supposed to, well, we're going to see what his duties are. Let's go see what his duties are. First of all, appointment. United States Attorneys are appointed by the President with the advice and consent of the Senate for a 4-year term. Upon expiration of this term, the United States Attorney continues to perform the duties of the office until a successor is confirmed. The United States Attorneys are subject to removal at the will of the President. So the question is, where's their commission? They were appointed, and the President shall commission all officers, all appointed officers of the United States. This is where they got to live. Authority. Although the Attorney General has supervision over litigation to which the United States or any agency thereof is a party, and has direction of all United States attorneys and their assistants in the discharge of their respective duties, each United States attorney within his/her district has responsibility. That would be the duty and the authority. So they have the duty and the authority to do the following. Prosecute for all offenses against the United States. Prosecute or defend for the government all civil actions, suits, or proceedings in which the United States is concerned. Pay attention now. C. Appear on behalf of the defendants in all civil actions, suits, or proceedings pending in the district against collectors or other officers of the revenue or customs for any act done by them or for the recovery of any money exacted by or paid to such officers, and by them paid into the Treasury. They have to defend, so the United States Attorney has to defend you in an IRS case. Right? You understand that? The United States Attorney has a duty to defend you in any case, any civil action, suit, or proceeding pending in the district against collectors. So if you have a lien against your property, then the United States Attorney has an obligation to defend you. If you have an ongoing court case, the United States Attorney has an obligation to defend you. If your loved one has been convicted, the United States Attorney has a duty to defend them. Please go talk to the U.S. Attorney. Go sit in their office until they come out and talk to you. Whatever it takes. Get on your knees, start praying. So I'm not leaving. I'm going to sit here and say the rosary until he comes and talks to me. And then do it. If you're going to say it, do it. Institute and prosecute proceedings for the collection of fines, penalties, and forfeitures, including for violation of any revenue law, unless satisfied upon investigation that justice does not require such proceeding. Everything you have ever gotten, more than likely, if you look in the IRS manual 6209, in fact, we're going to look at it right now, is a Class 5 gift or estate form. Where's it at? Here we are. I mean, please, download this. If you got any IRS issue, download this damn book and look at it. Or at least take Section 2 out of it. Tick-tock, tick-tock. Eventually it'll load. Come on, baby. Oh, baby. Train keep rolling. Add another car. Doesn't matter. We're still going uphill. IRS processing codes and information. This is the 2013 version. They put one out every year. It's also called the IRS Form 6209. But if you Google IRS processing codes and information, it'll take you to a IRS website, and you can click whatever years you want to look at. Section 2 starts somewhere in the 20s. Let's say like 28. Close enough. Actually, 25. Tax returns and forms. The following is a list of tax returns and forms showing file source, tax class, master file, tax account codes, and document codes. Tax class, tax class, tax class, right? What class tax does the form go to? Well, there it is, tax class. And they got, well, it looks like it goes from at least 1 to 8. Okay, so let's go look for some forms that we may know something about, like a W-2. Well, I'd be for tax class 5. Right? Anybody want to challenge the fact that it says W-2s are tax class 5? Well, then argue with the IRS. 4s? Well, I'd be tax class 5. What about a 10? What about how about a 1040 form? Right, the one you're going to put these W-2 information on. Well, that's either a 2 or a 6, but it's not a 5. 1040A is a 2. 1040C is a 2. 1040ES is a 2. 2, 2, 2, 2. As you can see, there ain't none of them is tax class 5. Why would you put the information from a tax class 5 form on a tax class 2 return? It just doesn't make any sense. How about 1099s? Well, look at that. 5, 5, 5, 5, 5. They're all 5s. 1096, 1098, 1099. They're all tax class 5. So why would you put that information on a 1040 form? That is tax class 2. 2, 2, 2, 2, 2. Get my point? Right? Whatever they did was against the law, and because it was against the law, well, this U.S. attorney has got a duty to defend the defendant, appear on behalf of the defendant. So now you think about this. When you go to a court case, IRS court case, not that I know that much about him, but the one guy who did stand up in court and say, I accept your oath, I bind you to it, remind you of a fiduciary duty, and I extend you my sovereign immunity while you carry out my orders to the judge, was told to leave. That day, he was sitting on one side, and on the other side was somebody representing the U.S. prosecutor, or the U.S. attorney, and the IRS agent. So the IRS agent was the defendant. Go figure. Now, of course, in that court case, they're not using your proper name. There's nothing the IRS does that uses your proper name. If you look at your tax returns, it's probably coming in your middle initial name. If you watch my last video, you'll see I've complained about that, and that I had gotten a call from the Treasury Inspector General, Tax Administration, and was put under oath to give a sworn statement, not to answer questions. So I gave him a sworn statement, and I said, I am not Robert A. Rytlewski. My name is Robert Allen Rytlewski. That is my full legal name, and it's the only name I recognize in things to do with law and commerce. If you want to sue me, that's the name you use. And that I want all records changed to Robert Allen Rytlewski, because the IRS has unlawfully converted my property to somebody called Robert A. Rytlewski. That isn't me, but they keep sending me the mail, so they've unlawfully converted my property. And so, hey, I need to get a hold of the U.S. attorney. I didn't know this was in here before, right? But again, this is well, here you are, United States Attorney's Manual, under 3.2, United States Attorneys, AUSA, Special Assistants, and the AGAC. You can read it for yourself. Another interesting point that was just shown to me today, brother that called me. Now, this is on the Secretary of State's website, Ruth Johnson, Secretary of State, Department of State, State of Michigan, wherein it says, notice to Michigan attorneys. The Michigan Notary Public Act requires all applicants for Notary Public Commission to file a surety bond and take an oath of office at the county clerk's office within the county of their residence. The act effective April 1st, 2007, amended the act such that Michigan attorneys at law, in good standing with the State Bar of Michigan, are no longer required to file a surety bond. However, they are still required to take the oath of office administered at the county clerk's office prior to forwarding the commission application to the office of the Great Seal. So, if you don't have a commission, right, prior to forwarding the commission application to the office of the Great Seal. So first you need to take the oath at the county clerk's office and then forward the commission to the Great Seal so that they can finish the application and give you your commission. That would be for an attorney. There has to be an oath on file, or they can't act as a notary. And they do act as notaries. So one of the things they get to do is act as a notary without putting up a bond because they're an attorney at law. But they have to have a commission. And so I forgot his name. The guy who was telling me this today. Sorry, brother. He's hot on this like a dog in a good bone. He's digging deep to see, well, where is this stuff? But right, if you have an ongoing deal with the attorney anywhere, either for who's supposed to be your attorney or against you, they're supposed to have gone down. This is one of the steps they need to do is file an oath of office in the county clerk's office as a notary, and then forward the commission to the office of the Great Seal. And once they do, from the office of the Great Seal, you should be able to get a certified copy of the record that they actually have a commission. And that really stumped the people here at the office. They said, oh, we're going to have to change what it says on that page or something like that. Well, that's still the same, but we'll see what they do. Okay, so what else can you do, right? Because I've written General Dunford, I've written clerks of the court, I've written to judges of the court, I've written to the Department of Justice, I've written to the Department of Treasury, I've written to the Department of Federal, the FCC, the FTC, the ABC. I wrote all of them. I write everybody complaints. Part of the reason I do that and then do this is so I can say, well, if they're not going to talk about it, I'm going to at least make sure it's seen by somebody else. And again, I hope somebody's watching. So I sent this to the Office of Public Affairs at the U.S. Department of Justice on the 13th, which I think is a couple days ago now. Robert Allen Rutluski, sui juris citizen of and relator for the United States of America. Put yourself at the top. Melanie Newman, Director, Office of Public Affairs, U.S. Department of Justice, 950 Pennsylvania Avenue, Washington, D.C. The United States of America wants to know, Ms. Director Newman, in the Congressional Research Service reports entitled, they're the ones that we read earlier, is found an outline of sorts for procedural requirements of a constitutionally valid judicial officer of the United States appointment after Senate confirmation. Paraphrasing, a combination of these reports. First, the President signs the commission. Second, the signed commission is transferred to the Department of Justice. Third, the Department of Justice engraves the date and the Attorney General signs the commission, then places the Justice Department seal. Fourth, the Deputy Attorney General then sends the appointee the commission, oath of office, photocopy of Senate confirmation, and possibly other various forms. I should have said by registered mail. 5. Upon receipt, the appointee is administered 2 oaths of office and signs the commission. 28 U.S.C. 453, 5 U.S.C. 331 contain the exact wording and style of the mandated oaths of office the appointees must be administered. Ms. Director Newman, please tell me, who is the custodian of the subscribed oath of office and commission? 2. Who is the Justice? Is the Justice Department seal different than the Department of Justice seal? Right? They like to turn words around. The county of Kent is not the same as Kent County. Yet they use them interchangeably, and they have you doing all this stuff with the county of Kent. But guess what? The county of Kent, with the name that way, is not the political subdivision of the sovereign state. It may be the name of a municipal corporation, but it's not a political subdivision of the state. Kent County is the political subdivision of the state. Name County is the political subdivision. County of name is a yet to be determined what it is, but it does have an EIN number, and it does take federal funding, and that's going to be detrimental to their health. What are the various other forms sent by the Deputy Attorney General? Who has the journal at the Department of Justice that evidences which signed commissions have been transmitted to the Department of Justice, right? Because they're supposed to come into the Department of Justice, so somebody has to log them. Who has the journal at the Department of Justice that evidences the appointees have been mailed by registered mail the signed commissions and various other forms? In and out, right? You got bookkeeping. These are legal documents. They have to be transferred. They can't be sitting someplace. Thank you, and I look forward to your quick reply, which I hadn't gotten yet. And so, since I hadn't gotten it, and I don't like to wait, because, I just don't like to wait. They owe me an answer. I said, well, who's the Deputy Attorney General? Because that's the one who's supposed to eventually get her fingers in this piece of paper to put into registered mail and send to the appointee. Again, Robert Allen Wertlewski, sui juris citizen of and relator for the United States of America. If you don't know what sui juris means, please go look it up. Respondent, Sally Q. Yates. Yeah, she uses a Q. That bothers me. Deputy Attorney General. Office of the Deputy Attorney General, U.S. Department of Justice, 950 Pennsylvania Avenue, Northwest, Washington, D.C. Ms. Deputy Attorney General Yates. June 13, 2016, I contacted the Department of Justice Office of Public Affairs looking for truthful answers to my questions on the Department of Justice's role in the appointment process of the officers of the United States. That office's lack of response now brings me to your office. My original inquiry to the Department of Justice is incorporated as a second notice of said request and forwarded as part of this email, and I await a reply. Article 2, Section 3 of the Constitution of the United States mandates that the President shall commission all officers of the United States. My initial question is simply, who has custody of the letters patent signed by the President and Attorney General, sealed, given to the Deputy Attorney General to forward by registered mail to the nominee, along with other documents having to do with the nominee's appointment that the nominee then has to sign to execute the appointment? I spelled the word wrong. Even when it's highlighted, I miss them. Then what? Where is the documentary evidence any of this happened? Ms. Deputy Attorney General Yates, do you have your letters patent signed by the President? Did you sign your commission and your oaths of office? Did your oath of office conform exactly to the oath found in 5 U.S.C. 3331? Are you aware that if you do not have these instruments of office, then you are not an officer of the United States? I make your conscience fully aware that you would be a usurper who is warring with the Constitution if you are not constitutionally appointed. Did you sign a standard Form 61 appointment affidavits as part of your appointment process? Did you know this form would invalidate your appointment as its construction bifurcates the wording used in the mandatory oath of office found in 5 U.S.C. 3331? I'm not saying that you meant to do this, or that you meant for this to happen, but is what it is. So you either have a commission signed by the President, the Attorney General, and you as appointee, and properly executed oath of office, or you do not. How about federal judges? Do they have properly executed commission? I was surprised not to find you listed as a member of the District of Columbia Bar. Is it not a requirement of the District of Columbia Court of Appeals that all lawyers practicing in the District of Columbia be members of the District of Columbia Bar? What bar have you been admitted to? Do all of its members use fictitious names in official capacities? How is it that you are a Deputy Attorney General and not a lawyer licensed to practice law? Are you in a parallel jurisdiction, one that allows the use of pseudonyms in an official capacity? How can you represent the United States using an unregistered alias? Does your commission, signed by the President, use your full legal name, Sally Quillian Yates or Sally Q. Yates? How about your application for appointment? What name did you use to identify yourself as a federal employee? I have sent a number of complaints about the laws of the United States being violated to presumed officers of the United States who also use fictitious names in alleged official capacity. Access to justice is being obstructed by de facto agents acting as officers of the United States but without constitutional authority. Are you one of them? Black-robed domestic terrorists acting as federal judges allow false accusers to perjure themselves as part of their satanic ritual to enslave the peaceful inhabitants of the United States. There are no courts in the United States whose proper names begins with the words "in the." Like, in other words, there's no "in the United States District Court for the Western District of Michigan." "In the" is not part of the proper name. Can't be at the top of the paper. No file number as required by procedure is to be found on any of these simulated legal processes, and the defendant is not charged in his or her full legal name. Do any federal judges have letters patent signed by the President and Attorney General and under the Justice Department seal? Let's ask that question just one more time. Did your office send the appointee a packet of forms needing completion? Can you confirm that the appointee filed procedures and signed these forms? Where is the proof? How about the United States Attorney for Western District of Michigan? Is he constitutionally appointed? If so, then why is he not fulfilling his duty of defending individuals in accordance with the United States Attorney's Manual Section 3.3-2.140- authority? Is a U.S. attorney different than a United States attorney? Sally Quillian Yates, you, having been enlightened to the facts, are now a witness or defendant in Lord Almighty's court of conscience. Lord Emmanuel, Christ Jesus of Nazareth, demands your testimony and will judge you by your works. You, your superiors and subordinates, either straighten out this mess or General Dunford shall by having you all arrested for war crimes. Amen. Yeah, General Dunford is a Jesuit. Yeah, if not, he was at least trained by Jesuits. There's a video that came out this year. It's Boston College High School commencement, and General Dunford was the speaker. You put enough of them words together in YouTube, you see the video with the general talking. So, he could send confessors with red-hot pokers in the middle of the night to see if people fear God, and then see if they come into work tomorrow and do the right thing. That would be the proper way to do it. Let's just go make sure that these Sally Quillian Yates, using a middle initial in an official capacity, do you really mean to blaspheme God, or do you fear God? If you fear God, use your proper name and go do your duty. Otherwise, the general will arrest you. I'm praying for it. And so, that's really what this was all about. A lot of good stuff in here. You should probably watch this video a couple times. I blow through it so fast, but at the end of the day, it's pretty simple. They have to have a commission signed by the President, or they're not who they say they are. And you don't have to take any bullshit they say for a different answer. You just tell them, unless you have a commission signed by the President, you're usurping an office. And if people say, well, what do they throw you in jail? Well, what of it? Right, get over it, man. I mean, take your persecution, take your hit for Christ, get out there and tell the truth, and let them and see what happens. You're telling the truth. This is what it says they have to have. You pointing out the truth to them is not going to be a problem. It's not been for me so far. I just call these people satanic sock puppets, and they won't do anything about it because I'm telling the truth. what they're depending on is that we never figure out how to untie the Gordian knot, right? By finding the civil authority ordained by God who wields the civil sword and will, sever flesh from bone. That's their problem. It's not mine. I'm trying to find them. Right? And I've never been bothered for telling the truth. And this is, to me, it's just telling the truth. It's just the way it is. They don't have to like it. I have to laugh. I've probably sent 7 or 8 emails now to the General Counsel of the Treasury, pointing out all sorts of crimes, shit that's going on. They don't block my emails. They still go in. Right? So whether they do anything with it or not at this particular moment, isn't always what matters. What matters is there's a record that you made them aware so that their deeds can be judged, because now they are aware of what's going on. And so the next thing for me is I'm going to contact probably my U.S. Attorney in the Western District, ask him some questions, and then ultimately to go to the appeals court of the Federal Circuit, which has nationwide jurisdiction over things to do with federal law. And I believe that is the court that you go to, not the Supreme Court. You go to this court, which is actually the Supreme Court, because it has judges. The other one has justices. This is the Supreme Court with judges. And you ask them to take superintending control of their attorneys that practice in their courts, because this would be all the federal courts, right? Do with a federal matter. It isn't any particular district. It's all districts in matters to do with federal law. And point out to them that these people don't have a commission. And so, where you think you have a district court judge in some district, what he really is an attorney who was licensed to practice law in that district that's just pretending to be a judge. Now, even if the president signed a commission and sent it to him, if this guy didn't sign it and put it in, well, then he isn't done. He's still an attorney just acting like a judge. And therefore, he's got a mental disability because he thinks that he can just act like being a judge instead of actually taking the office. And you can complain about that stuff, say he's mentally incompetent. To the appeals court, say because the dude hasn't filed his frickin' file for record, his oaths of office and his commission. So the question is, where are those supposed to be kept right now? And I think one of the places is human resources of the court that they belong to, and that'll be the other people I get a hold of, is just human resources, asking them for a copy of the commission and the oath of offices of the judge that's sitting there in judgment, and of the U.S. Attorney. In fact, just tell me who you have one for. Who do you have a commission for? So we'll see where that goes. But they don't have any paper people, so don't be afraid of them. I mean, unless we go point it out that this is the problem, it will never get solved. Because they're going to continue doing what they're doing, but it's all illegal. It's all done by domestic terrorists, and you allow it to happen is your fault. And my fault, right? But I'm trying to do what I can. I don't know, that's all I can do, but, I don't have much I can do because I can't pay my fucking rent. So all I can do is sit here and send emails. So there we are. You can help me out. Go back to the beginning and find my name and so forth and send me a donation. Be much appreciated. In the meantime, I got to get back to work because that's what I do. Okay, y'all have a great day, and I hope you got something out of this. We'll see ya.